Okay, Assalamualaikum everyone. We have done on the first part of the Malaysian legal system, which is mostly on the parliament, sources of law, introduction to law, judicial system, and now we are moving on to the second part, which is starting from law of tort, and then we're going to do law of defamation, and then we're going to look at nuisance, we're going to look at land law. Okay, so we are moving on to the second part, which is more the questions are more towards problematic questions, but then again, you still need to know the law. There's a possibility that you might also have essay question. So what is law of tort? Before we move on, you're going to look at what does it mean by tort. Okay, now tort means wrong. Okay, so either a wrongful act or something which is omission, which you did not do. So either you do something wrong or there's a failure to do something. Okay, and there are a lot of types of civil wrong, such as breach of contract, breach of trust. Okay, now when we talk about wrong, we need to know what are the things. Okay, now look at this example in your understanding of what is wrong in law, right? What is wrong, morally wrong, or anything related to the law of torts, how you can actually differentiate. We're going to see it slowly. Now look at the example. If B were drowning and he called out to A for help, and A failed to come to B's rescue, so A would not have committed any tort towards B, correct? He did not do anything wrong towards B. Okay, but then A's behavior would be a moral wrong. Okay, morally you're wrong. Why? Because you don't help B. You didn't rescue B. Despite it's a wrong, but it's not tort. Okay, when we talk about tort, it is something a legal wrong. Okay, so in this example, even if A failed to rescue B, A does not commit any tort. So when we talk about wrong, we talk about legal wrong, and legal wrong falls into two categories. Either they are civil or criminal in nature. Okay, now the victim of tort will be given the rights to take action for an unliquidated damages. So basically, the court will fix how much you have to pay the victim if you have committed any civil wrong. Now, for example, if you bring an action for defamation, it is entirely up to the court to decide whether to award you 10 cents or 50 cents. So it all depends on evidences, how severe the damage is, right? So there are a lot of things to consider when cases go up to court. Okay, now for definition on what amount to tortious act, okay, or what is law of tort. Okay, so the author, Winfield and Hallowis, in the law of tort, okay, in 1994, he states, okay, tortious liberty arises from the breach of duty primarily fixed by the law. Okay, now this duty towards persons generally and its breach is redressable by an action for unliquidated damages. What it simply means is that the law provides such duty, okay, and you have failed to actually fulfill the duty. You have actually breached the duty, and because of the breach, someone actually suffered damages, and because of that, that particular victim can actually apply to court for damages. So damages that is not fixed, or what we call unliquidated damages. Okay, this is unliquidated damages. Okay, so the court will evaluate how much to pay. Okay, when we talk about tort, okay, we talk about liabilities. Okay, what is liabilities? Malay words, tanggungjawab. Okay, so when we talk about liabilities, okay, it's either arise from a wrongful act, which is something you have done wrong, or a wrongful omission, failure to do it when there is a duty to act. So basically, when we talk about tortious liability, we talk about fault on the defendant. So when we talk about fault, okay, the claimant or the victim, they must prove that defendant has committed the act intentionally or negligently. Not only the claimant have to prove that defendant acted intentionally or negligently, claimant must also prove that he or she has suffered damages. And damages must not be too remote, of a consequence. Too remote here means you know that when you push somebody, for example, you know that he will actually fall, and then if he actually once he fell, he might hurt himself. Okay, that is may not be too remote. But assuming if you are driving a motorbike, you're skidded, okay, and then you hit someone very near you who is actually walking by the roadside. You know that as you were driving the motorbike and your motorbike skidded, you know that you're gonna hit the person who actually walking by the roadside. But do you know that when your motorbike is skidded, it actually goes that far and it hits someone else? Now the issue is that, is it too remote? Do you know that as a result of the motorbike fell down, it actually can hit someone else that is far away? So if it's too remote, although that particular victim has suffered damages, they might not be able to prove. Okay, but it all depends on the cases. We're going to look at those in this later in the topic. Yeah. Okay. So basically, the law of tort, we are looking into the act of tort itself, and it actually consists of a wrongful act, which due to a breach of duty, and he has causes injury, and it can be remedied by unliquidated damages. So unliquidated damages will be ascertained by the court. Okay, these are the topics under law of torts: trespass to person, trespass to land, negligence, defamation, and nuisance. But for our purpose, we're only going to do trespass to person, negligence, nuisance, and defamation. We are not going to go into trespass to land. Okay. Okay, when we talk about trespass, we talk about intention. Look at this case. In the case of Litang and Cooper, so how do you pronounce this? Litang, which is the plaintiff. This is versus, but when you write it as V. But when we to pronounce it, we pronounce it as N. Cooper, reported in 1964, Volume 2, All England Report, at page 929. This is how what we call a proper citation of law cases. I'll show you why, the reason why we call this N. But before that, let me just finish off this case. It was held that in the tort of trespass, there must exist intention at the time the defendant does his act. So we talk about trespass, we talk about intention. Now, when somebody is careless, he is not a trespass, he is a negligent. So an important element in establishing trespass, defendant must be proven to have acted intentionally. So in this case, if Litang sue Cooper for trespass, Litang must prove that Cooper has the element to act intentionally. Okay, we're going to go into detail in the next trespass to person. When I said I wanted to show you how does the word and comes about. Okay, just now was Litang v, as in Litang versus Cooper. This is the original document submitted to the court. Look at this case. Dalam Mahkamah Session di Seremban. Okay, this is where the Sessions Court is situated. And in dalam Negeri Sembilan, Malaysia, read number. So there's an empty space here, which normally the court will insert. Read number, whatever read number for that year. So tahun 2012. So this case, when it was filed into court, this case in between antara Bank Simpanan Nasional as plaintiff dan Rohani binti Muhammad Ismail as defendant. So this is where the V comes from. So it's the case between Bank Simpanan Nasional and Rohani. That's why when we pronounce Litang V versus Cooper, when we write it's actually V. When we pronounce it as SN. So this is how a court document look like when you first file in. So this is a read. So read given to Rohani as defendant. So she has two addresses. So we send to both addresses, and she has to appear within 14 days after the service of the court document. Okay, this document is actually being witnessed by the plaintiff lawyer or plaintiff solicitor. And it's actually sealed by the Timbalan Pendaftar. And after that, there's a memorandum saying that this writ cannot be served on the defendant more than 6 months. So the moment you file in today, the court will return back duly sealed documents so that you can actually serve on your defendant. And if it's after 6 months, you cannot use the same writ. You have to apply for extension. Okay, or if you still cannot actually serve on the defendant, you have to apply for substituted services. Okay, these are the endorsement of claim, something like 88,000 plus. This is the endorsement of the lawyer. Okay, then this is the statement of claim. This is the story of the case. Who is a plaintiff? Who is the defendant? Okay, and there was a loan being given. Loan 36 months, 360 months, to which monthly payment is about 339 ringgit and 43 cent. And these are the things on the loan. Okay, this is on housing loan. And then because of that, defendant had to pay certain interest from the loan. However, this agreement stated that defendant telah mengingkari terma-terma secara gadaya, meaning defendant has breached the terms of the agreement, and namun defendant masih gagal, ingkar dan atau enggan menyelesaikan jumlah, failure to pay. And this because of that, this what we call, this whole thing is what we call prayer. Prayer, prayer. As if you are in during your prayer, you pray to God. So this is you pray to the court, claiming for your money of 88,658 3 cents from the previous from the defendant. Okay, and then interest. Okay, the cost of the proceedings and date of the summons. So this is the writ. Okay, this is how when you start off your whole process.